Welcome everyone. We're going to give it just a minute as people show up. Okay, in the interest of time, I'm going to start. Good afternoon, everyone. We are so thrilled to be presenting this timely panel entitled Title VII U.S. Supreme Court Decision, a Discussion and Analysis, jointly sponsored by the ABA Commission on Sexual Orientation and Gender Identity and the Section of Civil Rights and Social Justice, and co-sponsored by our friends, the ABA Young Lawyers Division. This panel is one of many in a series of rapid response webinars. We're actively planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on these programs. Before we go into our program and how today will work, I'm pleased to welcome the President of the American Bar Association, Judy Perry-Martinez, and thank her for being with us today to share her remarks during our webinar and discussion on the monumental Title VII U.S. Supreme Court decision. Judy?
Thanks, Skip, and thanks to all of you who have gathered, SOGI commissioners, members of the Civil Rights and Social Justice Section and Young Lawyers Division, and so many more who care so much about these challenges and issues that have been faced for so long. What a week this has been. And I can tell you that I selfishly wanted to be with all of you because I wanted to get a sense, and I'm seeing it at the panelists' faces right now, the sense of the smiles and the joy and the pride and just the sense of this moment. Because I have seen the anguish and the hurt and the hardship and the aches in the legs when people stood tall no matter what and no matter who tried to push them down. But they stood tall for what they believed in. And the ABA at least played, some part over the years. I remember the feeling that I had when I saw the decision pop up on my phone this week, and it reckoned me back to 1989, standing in the House of Delegates, when I believe the first policy was passed by the American Bar Association, adopted by the ABA on non-discrimination against the LGBTQ community. And I remember not knowing what was going to happen in that vote and feeling at that moment that sense of finally we are here. And yet it took so long, decades of hard work by so many people on this webinar, not only the panelists, but so many more who worked so hard to just make sure that this day would come, that Bostic and the other cases would come forth. So you have our gratitude for your courage, for your resilience, for your fortitude to keep pushing on. The American Bar Association was proud to file an amicus in the cases and to stand with all of you to know that there is so much more work to be done. But at this moment, we should celebrate and we should just applaud the fact that now it is the law, and now it will be that workplaces all over this country and the world, we hope one day, will be able to experience and benefit fully from the extraordinary intellect and talent and dedication of our wonderful community of LGBTQ members. So thank you so much for all you've done, and I'm just delighted to sit back and listen to your words of wisdom.
Thank you, Judy, for those amazing words. During today's program, we are encouraging you to ask questions of our panelists through the Q&A function, not the chat function. If you don't see these controls, please ensure the screen is not idle. We'll address questions at the end of the panel as time permits. We'll be sharing a recording of this program to everyone who is registered so you can share it widely with your networks. And with that, we're thrilled to bring you today's program, Title VII U.S. Supreme Court Decision, a Discussion and Analysis. My name is Skip Harsh. I'm the director of the ABA's Commission on Sexual Orientation and Gender Identity, and I have the humble honor of being able to moderate these four fantastic speakers who really need no introduction, but I'm going to let each one of them introduce themselves and say a few words. So I'd like to start with, hi, if I could.
Hello, everyone. Isn't it great to be here? Sorry, a little excited. Sorry. So about, I was in commissioner at the EOC from 2010 to 2019, when the EOC issued a series of decisions covering gender identity and sexual orientation discrimination under Title VII. Prior to that, I was a law professor at Georgetown Law School for 18 years. And during that time served as a consultant to various groups and worked on helping to draft the original Employment Non-Discrimination Act in 1993, worked in terms of expanding that to include not just sexual orientation, but also gender identity. And in 2000, because I want to check the date, I published a law review article arguing that both sexual orientation and gender identity were covered as forms of sex discrimination, not a new theory in the academy. Sylvia Law had said that in the 1970s, but sort of playing that out again in the context of why it made sense to put gender identity into ENDA if we had sexual orientation in ENDA, because both sexual orientation and gender identity. Oh, I'm sorry. And now I'm a partner in Morgan Lewis and Bockius, and I'm director of workplace culture consulting. So I'm essentially just helping companies and organizations create safe, respectful, diverse, and inclusive workplaces. That's a good thing to do.
Great, thank you. Carmelyn?
Hi, I'm Carmelyn P. Malalis. I am the chair and commissioner for New York City's Commission on Human Rights. We are the city agency that enforces anti-discrimination and anti-harassment protections, including those that exist in employment, similar to the issues that were presented in the case. And prior to that, I was for years a partner at Outten and Golden, which is an employee-side labor and employment law firm, where we focused on various employment issues. But I had the great privilege years back of, with one of my partners, co-founding the firm's LGBT workplace rights practice group, that at the time was considered one of the first such practice groups, because a lot of folks were thinking, you know, there's no rights. What's the business in that for a private law firm? But I had the great privilege of working with folks like and Shannon and some other folks as some of this law was developing. So it's a real honor and privilege to be here with everyone today.
Louis?
My name is Louis Lopez. I'm the Associate Special Counsel at the U.S. Office of Special Counsel, or OSC. For those of you who don't know, we're the agency that investigates and litigates civil service violations, and that includes cases of discrimination and whistleblower retaliation. Prior to working at OSC, I worked at the Department of Justice Civil Rights Division and also at the EEOC, for which I am so proud and forever indebted to that amazing experience. In all of those positions, I've worked on LGBTQ issues and cases, both in the private and in the public sector. And I just want to say that I feel really lucky and excited to be a part of this discussion today. For several reasons, I feel privileged to be presenting with people who I consider real heroes to me along this journey. And I think that getting this decision at this particular time in history is meaningful. And I mean, don't we really all want to do over for 2020 so far, except for this week? So this decision really is a shiny, happy time during what have been really dark, a very dark period for Americans. And so let's take this moment to understand and celebrate this landmark victory before we re-engage in efforts to continue to find a discrimination-free and more inclusive workplaces for all of us. Thank you.
Thanks, Louis. Shannon?
Yeah, I'm with you, Louis. Let's celebrate. Yeah, it is so amazingly great to be here. Yeah, I'm Shannon, mentor, longtime transgender activist and attorney, and I'm the legal director of the National Center for Lesbian Rights, and one of many, many attorneys and advocates who for decades now have been trying so hard to get courts to accept that discrimination against LGBTQ people is part and parcel of sex discrimination, is sex discrimination. And it's pretty awesome to have that theory, that argument finally recognized and validated by the highest court in our land in such a strong opinion, and authored no less by a a justice that was put on the court by President Trump. And it's just, I think, a real tribute to the power and strength of those arguments. And just want to say real quick that it's been such an honor, Hai, to be doing this work under your leadership and inspired by your incredible intellect and just unwavering energy and commitment to making this happen. So thank you.
Great. Thank you, everyone. Going to start, Carmelyn, could you give us a quick breakdown of the decision, with the issue, the court holding, and sort of the essence of the ruling?
Sure. So just this past Monday, the Supreme Court ruled in Bostock that firing employees because of their sexual orientation or gender identity is sex discrimination that violates federal law, or the Civil Rights Act of 1964. And this ruling resulted pretty much from 3 separate cases. They were brought by Amy Stevens, Donald Zarda, and Gerald Bostock. Amy Stevens worked as a funeral director for 6 years, and she was fired after telling her boss that she was a transgender woman. Don Zarda was a skydiving instructor, and he was fired after he told a customer that he was gay. And Gerald Bostock was a social worker working with at-risk youth, and he was fired from his job after his employer learned that he was gay. So all 3 of them sued, asserting that it was illegal sex discrimination under Title VII to fire them for being transgender or gay. And we are here today and we're excited because the Supreme Court agreed. Yay! Holding that, and I have it here, holding that an employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. That's Bostock at 2, and that's the language directly from the decision. So stated differently, an employer who fires an employee merely for being LGBT violates Title VII. And I think tragically, kind of the epilogue on this is that 2 of the courageous plaintiffs, Amy Stevens and Don Zarda, they passed away before this decision was released. Mr. Zarda died several years ago in an accident, and Amy Stevens passed away just last month from kidney failure that was exacerbated when she lost her health insurance as a result of being fired. But obviously all of us owe them, their families, just immense gratitude for being courageous enough and brave enough to push these cases forward.
Thank you. Hi, could you talk a little bit about the evolution of the case law and the extremely important role that you've played in developing it, and of the EEOC in that regard?
Sure, and actually the EEOC played a very important role in the beginning as well as more recently, because it does seem so logical when you say you can no longer discriminate based on sex that, well, that means if I've transitioned, right, from one sex to another and I'm fired for that reason, what is that but because of sex? Or as Carmelyn read from the opinion, if, my coworker, Martin, has a picture of his wife, Nancy, on the desk and everything's fine, and I have a picture of my wife, Nancy, on the desk and I get fired, what is the difference between me and Martin? Only our sex, right? So it seemed obvious. And to be honest, in the early 1960s, people thought they could bring those cases. And we had a gay person bring a case to the EEOC. We had a transgender person bring a case to the EEOC in the late 1970s. And EEOC just literally in like 3 paragraphs, decisions, if that, just said, no, you're not covered. I mean, and the entire reasoning was Congress didn't intend it. So that was it. And the court started agreeing with that. Then we had a little bit of a shift when we had the Price Waterhouse case where the Supreme Court says, well, gender stereotyping is a form of sex discrimination. That really helped transgender folks. I mean, Jennifer Levi, Shannon's colleague, brought one of the first cases where a transgender person got protection under a sex discrimination law. We got that in employment cases. 2011, we got from the 11th Circuit, really the strongest probably transgender protection case, but all based on gender stereotyping. So it wasn't like every case of gender identity discrimination is sex discrimination. then we sort of had a revolution in terms of the EOC. The EOC, again, by putting out different analysis, helped change the legal landscape. So in 2012, in the Macy decision, which was easier for the EOC to do because there were all these cases that at least was applying gender stereotyping to transgender folks. But besides the gender stereotyping argument, saying it's always based on a gender stereotype if you discriminate against someone based on gender identity, there were also 2 paragraphs in that decision towards the end that said, and you know what? You don't even have to go to gender stereotyping. It's because of sex right off. And we sort of pulled out from the Price Waterhouse case, which had only been quoted for sort of gender stereotyping, the one sentence that said, sex must be irrelevant to the decision. And then gender stereotyping was simply an example, evidence that sex had been taken into account. So in 2015, when the EOC had a case dealing with sexual orientation discrimination, that was the first argument that was put forward. And those who know me know that that was my favorite argument. So that's why it was the first one in Baldwin. And again, it was just very simple textual analysis in the way that I described. And then 2 other theories, the gender stereotyping theory and an association theory. You know, the agency, though, is just an agency. It made a difference because starting from 2012, EOC started taking charges from LGBT people, hundreds and then thousands who came. But it's still just an agency. You needed the courts. And what happened after 2015 with sexual orientation, where all the courts, almost all the appellate courts had just pronounced sexual orientation isn't covered, they used the gender stereotyping to help some gay people. Like me as a lesbian, I wouldn't have worked. I conform to gender stereotyping, right? Other than the most core gender stereotype of who I should be attracted to. But otherwise, the courts were just not there. After Baldwin, courts started using that decision. So suddenly something that had not even been percolating in the courts in any way on sexual orientation started getting brought forward. And let me tell you, this is because of the LGBT legal groups that got in there, EOC bringing litigation. So then they start coming up, and then 7th Circuit, you have to go en banc to overturn precedent. They do. 2nd Circuit, you have to go en banc to overturn precedent. They do. 11th Circuit did not overturn its precedent, and that's what brought these cases to the Supreme Court. And then at that point, let me tell you, the textualist theory is pretty straightforward. And it's once a court actually has to deal with it, it's sort of like the emperor has no clothes. The arguments against it really just fall. And let me tell you, Justice Gorsuch is a really good writer, and especially when it comes to textualism. So that's how we got here.
Great, thank you. Shannon, I'm gonna turn it over to you and then to anyone else about how the court's analysis really fit into the evolution that was just described.
Yeah, so I mean, highlighted out. So I'm just gonna add just a teeny little bit more, but as Hy noted, the Price Waterhouse case, reinvigorated this whole gender stereotype, emphasis on gender stereotyping, and it made it possible for us to start arguing using that and saying, hey, gay people depart from the gender stereotype that a man should only be attracted to a man, a woman should only be man should only be attracted to a woman, sorry, and that a woman should only be attracted to a man, and that it's a kind of gender nonconformity. And the same with transgender people. We're like, oh, well, a transgender person is not that different from the plaintiff in Price Waterhouse. It's just kind of an extreme case of gender nonconformity, so we should be protected. But the better argument, the one that is more protective of our community and more consistent with who transgender people really are, and I'll say that a little bit more about that, is what Hy just referred to as the textualist argument, or you could also call it the per se argument. Just a very straightforward claim that by definition, being gay or being transgender has everything to do with your sex. You can't even identify a person as being gay without taking their sex into account. You can't even identify a person as transgender without taking their sex into account. It just lies at the very heart of both of those identities. So One of the potentially problematic aspects of using gender stereotyping, particularly for transgender people, is that it kind of tends to posit the transgender person as forever a member of their birth sex. And just and you're like somebody who's assigned male at birth, dresses and appears as a woman, but it just is, it conceptualizes it as, again, a kind of just extreme gender nonconformity, which is helpful conceptually, and it was great to get courts to start opening their minds and thinking about the possibility that we could be covered under sex discrimination law, but it has definite limits, particularly when you think about cases that involve whether a transgender woman, for example, should be able to use the women's restroom, or whether transgender girls and boys should be able to play on girls and boys sports teams. Then the gender stereotyping theory is actually not so helpful, because in those instances, it's really important that the law acknowledge that, yeah, a transgender woman is a woman, a transgender man is a man. So the per se or textualist argument is much more helpful, much more powerful than the gender stereotyping argument for most purposes. And the wonderful thing, as Hai just noted, one of the really terrific and in some ways somewhat surprising aspect of the decision that we just got from the Supreme Court is that the decision went 100%, 110% down the per se textualist lane of adopting just straight up in the most direct possible way, agreeing with the longstanding argument that Hai was one of the first to make, and that the EOC had embraced, that just by definition, when somebody discriminates against a gay or transgender person, they are taking that person's sex into account, and that is impermissible sex discrimination under Title VII, and I might add under every other federal sex discrimination law. But that's a segue to our next topic.
Great, thanks, Shannon. I don't know if anybody else had anything they wanted to chime in on that. If not, I'm gonna turn it over to Louis. My kind of question is for you. How long do you think it will take to enforce this decision throughout the nation? And really, what's going to be involved in doing so, and including sort of this retroactive application question that is on everybody's mind?
That's a great question. And I think how long enforcement will take and what will be involved really needs to be unpacked a little bit, because I think it strikes at the larger and more fundamental question about when we as the LGBT community will feel the true impact of this decision. And speaking for myself, I felt it immediately. I mean, using the words from Price Waterhouse, the decision was simple but momentous. It immediately validated people in our community in a dignified and public way that doesn't always happen by our leaders and institutions. It also immediately empowered us to know that we can be our complete and authentic selves, both in our homes as well as in our workplaces across the country. And finally, not worry that we have no recourse if we are denied employment, harassed, fired, or otherwise discriminated because of our sexual orientation or gender identity. I think in addition, the culture change around the LGBTQ plus community issues that we've been witnessing for some time now will only continue to increase. Indeed, prior to this decision, many employers across the country were already understanding and appreciating the value our community adds to the workplace. Now that it is clear that the same law applies coast to coast, I expect more and more acceptance in workplaces. I think enforcement of traditional personnel actions like hiring and firing are going to be really clear. Other basic terms and conditions of employment that our community cares deeply about, like bathroom usage and dress codes, they may take more time to flesh out in the courts. I will note, however, that the decision offers signals of hope that these might not be so difficult. For example, the majority clearly said that while it was not deciding those types of issues because they weren't before the court, it's not going to prejudge those questions, signaling that they have an open mind about any decisions when they do come up. Moreover, the decision used the right pronouns and treated Amy Stevens as the woman she is, rather than a gender nonconforming man, perhaps demonstrating that these were actually maybe non-issues in the end. But if, however, these issues do need to be litigated in order to realize fuller enforcement of these protections, I think the decision offers a few key points. For example, the majority defines discrimination as intentionally treating a person worse, and states that discrimination involves distinctions or differences in treatment that injure protected individuals. So some of the questions we might think about is what impact, if any, will these definitions have on other cases challenging, for example, bathroom usage or dress codes, when and if those cases arise? And how will individuals show that their treatment is injurious or worse than others? And what will employers' defenses likely be? These are the discussions that have been happening and should continue to happen in the LGBT community and throughout workplaces. And I think we're going to talk more about these and other issues as the next battlegrounds for enforcement of the decision. Lastly, and quickly, I'll talk about retroactivity. Judicial decisions have a general presumption of retroactivity in that they are meant to interpret the law as it exists, indeed as it has always existed. Here it is clear that the majority believes that Title VII prohibits discrimination and has always prohibited discrimination based on sexual orientation or gender identity by virtue of the statute's overt bar of sex discrimination. In fact, I found it amusing that Justice Gorsuch cited the little known canon of the elephants in the mouse holes that was first mentioned by Justice Scalia in a 2001 opinion to make the point that the supposed elephant, that is the holding in Bostock, was never really in a mouse hole and that it was in plain sight sitting there in the statute since 1964. And to be clear, EOC has been accepting and investigating charges, as Kai said, for some time now. It has codes for such protections. It's going to continue to process those claims. And courts now should be using this holding to adjudicate all pending Title VII cases that are before those courts. So hopefully enforcement will be as swift as necessary, and perhaps more important, fall on the side of equality, fairness, and dignity.
Thank you, Louis. Carmelyn, could you address the impact of the decision on state law and sort of state human rights commissions, HRCs?
Sure. Yeah, I also just wanted to quickly add to what Louis was saying. You know, I'm videoing in from Brooklyn, and where just a few days ago we had, I think, over 15,000 people coming out, pouring out on the streets in support of Black trans lives. And so, you know, one note that I think is has to be made is that, you know, this basically puts LGBT folks, you know, at the courthouse door for these sorts of cases. But for many Black and brown trans people, they can't even get a job interview. They're so locked out of employment or the workplace because various forms of discrimination. And so for them, I mean, in terms of the power of this decision, it's powerful, I think, for our communities as a whole. And we also have to think about what happens for the folks who are locked out of the workplace completely. I'm in Brooklyn, so I had to say that. You know, turning to the effect, you know, for purposes of other state fair employment practice agencies like mine and other state human rights laws related issues, you know, Bostock only applies to employers with 15 or more employees because that's the jurisdictional threshold for Title VII. In order to be held to obligations under Title VII, an employer must have 15 or more employees. So if you are a business or an employer and you have less than 15 employees, Title VII doesn't apply to you, which would also mean that Bostock doesn't apply to you. And states and localities, they often have their own human rights protections, just like New York City and New York State. Some of those protections mirror Title VII's jurisdictional requirement, and others have lower thresholds. So for instance, in New York State and New York City, we only require that businesses have 4 employees. So if you have 4 or more employees, you are covered then under our laws. Now, states generally have the ability to interpret their own statutes, but Bostock doesn't necessarily apply in those other spaces. But, you know, in some states, and this is what we were talking about a little bit earlier, in some states, their case law interpreting their state statutes actually references or goes back to Title VII. It actually says, you know, we're going to, as they said in these Title VII cases, we're going to apply a Title VII analysis here. And so in those states, I think there's going to be a really strong argument that Bostock should apply and that LGBT people should be covered under their own because of sex provisions, because they're going back to a Title VII analysis. You know, the other thing is that state and local FIPAs or other human rights agencies, you could issue your own guidance or your own enforcement directives that say explicitly that you are interpreting your laws consistent with Bostock. For human rights agencies that also enforce protections in other areas, like for instance, the City Commission on Human Rights, we enforce protections in employment and in housing and in public accommodations. You can say very broadly that you are taking the same analysis and applying it across the board in those different areas in order to provide broader protections. You know, one thing to note is that many of these state and local human rights agencies, they are highly reliant on federal funding. A lot of them get their money directly from the EEOC. And in order to get that money, they basically have to cross-file their cases. They're saying they are taking a case that the EEOC could have taken. So the other thing is, in order to avail of that EEOC money, it could be the case that they would also have to apply their local or state statutes consistent with the Title VII analysis in Bostock.
Thanks, Carmelyn. I do want to just note, we do see your questions, and I think the next couple of topics are going to address a number of them. Hi, I was hoping you could talk about the precedent impact areas not covered by this case, such as, you know, healthcare discrimination, housing, education, and, you know, implications for transgender individuals in prisons, really just how it's going to affect these areas.
Sure, and Carmelyn really got us off going on that quite well, right? And actually, though, quickly before I do that, because I want to follow up something on the question about just practically, how is this going to work that Louis really got us going on? It is really important that the EEOC since 2012, I mean, that's 8 years, has been taking in these charges. And what was interesting is that, you know, like, why did people start showing up at the EEOC? I was like, my God, did they read the Macy decision? Did they read, you know, we had the early decisions, Veredo, Costello. No, you know, the polls say that most people think it's illegal to fire someone who's gay, right? And so people who were fired or being harassed, they would come to the EEOC. Before 2012, they were just sent away. And what happened after 2012, as they came, they started being able to have their charges investigated. And that was really important for states that were not like New York or California that didn't have their own laws. So, and the codes, right? Like there are actually codes under sex since 2012 in the EEOC digital system for gender identity, for sexual orientation. So, so the EEOC folks are ready, you know, to just keep doing what they're doing. So now the question is, what about the folks in education and in housing and in healthcare, right? Because you can also go to those agencies for administrative relief. Well, based on the reasoning, there really should not be a difference between Title VII or Title IX, which is about education, or the Affordable Care Act, which is about healthcare, or the Fair Housing Act, which is about sex. So any of those federal laws, in fact, Justice Alito helpfully listed them in Appendix C, many laws that prohibit sex discrimination. Based on how courts have gone to in the past, my guess is they will be interpreting, you know, as cases come up, they'll just interpret sex in the same way. Obviously, it's sort of better if the agency, sort of before anything goes to court, the agency says, oh yeah, so this is now new guidance. Well, you know, I mean, obviously we'll have to see what happens on the federal level, whether they do that. Although even if they don't, like I say, it's sort of irrelevant. It matters ultimately what the court says. But certainly on the state level, that's where just reinforcing what Carmelyn said, that's not a heavy lift for state agencies to put out the one pager that says, oh yeah, and here are the 15 laws that prohibit sex discrimination in our state in these areas, and Bostock applies. And I think we will see that.
Right, and just to add to that, and for state and local agencies, you could go beyond some of the things that were mentioned in the opinion. One of the resources that I shared for the program was the legal enforcement guidance that my agency had put out in 2015 on discrimination based on gender identity and gender expression that became part of our formal rules just last year, but has examples kind of across the board, including, we made it actually into Alito's dissent, where he was mapping out the different places that this could go. So I think this is a time for states and localities to be bold.
Thank you, Carmelyn. Another question that we've been seeing a lot of, and this is sort of for Shannon and Lewis, is pending cases that will be affected. Shannon, at your organization, the National Center for Lesbian Rights, Lewis at the EEOC and others. So I guess, Shannon, if I could start that question with you and then toss it over to Lewis and maybe Carmelyn as well.
You bet. And I meant to mention before, there's a new piece out by my brilliant former colleague, Alex Chin, who's now running the new LGBT rights clinic at Harvard Law School. That's just published today in Slate, that talks about the interplay between the gender stereotyping and the per se argument and the evolution of that. So I encourage everyone to take a look at that. And I also just wanted to echo Carmen's comment that about the importance and centrality of the issues being raised by the Black Lives Movement, Black Lives Matter movement at this moment. And I'm thinking of something that Nadine Smith, the executive director of Equality Florida, said the other day, that whether you're talking about marriage equality or employment equality, any of the rights that we've worked so hard to achieve don't mean anything to Black people if they can't live, if their lives are literally on the line. So it's a very important thing to remember right now. And then related to that, I also want to call out something that I think doesn't get enough attention, which is Black transgender women have been absolutely at the forefront of the legal movement and the legal cases to establish all this precedent that we're talking about. Just want to give a real quick shout out to, well, the very first case that I am aware of, and how you may know differently, but that where a court ever recognized the sex discrimination theory for protecting a transgender person's right to live and dress and just be who they are, was brought by my colleague Jennifer Levi. It was actually a state court case. It was in the late 1990s, and the plaintiff was a Jane Doe plaintiff, but she was a Black transgender girl. And Dee Farmer, we shouldn't forget about her in this moment, the very first openly transgender plaintiff ever to appear before the US Supreme Court back in 1994, a Black transgender woman seeking and obtaining rights for incarcerated transgender women to be protected from sexual violence. And then the precedent-setting, groundbreaking case in the Sixth Circuit, 1 and 2, was brought by Felicia Barnes, another transgender woman who got that court early days, and that was pretty conservative court back then, to embrace the sex discrimination theory. So I just want to say that stuff real quick. And then in terms of like pending cases that we have, I can do that really fast. Just like everyone's been saying, like, look, this was huge. This was not just Title VII. This is every federal sex discrimination statute. There's no reason the court would have a different analysis in any of them. So we've got a case pending in the 8th Circuit right now that's been stayed pending the decision in Bostock with a lesbian couple who were excluded from a retirement community just because they were a same-sex couple. Brought a case under the Fair Housing Act. That case is about to be reactivated, and I'm feeling pretty good about our chances in light of Bostock. There's a number of Affordable Care Act cases that raise healthcare claims, especially for transgender people. And the other Title IX, there's a bunch of Title IX cases out there, including the ones where, one in Connecticut, where the Alliance Defending Freedom is trying to attack Connecticut's very inclusive policy for letting transgender girls play on girls' sports team. I think that case is in trouble, very serious and well-deserved trouble after the decision yesterday. So look, this goes way beyond employment. It really touches on every single area that's covered by federal sex discrimination law.
Lewis, do you have anything to add?
Sure. A couple of things. One is just building on what Shannon said about the trans community and the particularly the Black and brown trans community. It struck me that some of the other questions that we got about why perhaps this decision was written by Justice Gorsuch and the significance of that. And there was a particular part during the oral argument that showed up in the decision as well that I thought it was worth noting. He suggested that judges should engage in judicial modesty when interpreting statutes that are old, and his idea that maybe that would be better appropriately done through legislation as opposed to interpreting statutes. And in the decision, he sort of modified that position. He used a similar term, judicial humility, but he said that it requires judges to refrain from adding to statutes just the same as it requires them to refrain from diminishing them as well. And in those words, in spite of whatever, in other words, I mean, in spite of whatever ills people may think will follow, but incidentally haven't materialized at all, Title VII provides these protections, and we shouldn't read them out of the law because they were once or are disfavored or unpopular. And that sort of resonated with me. And I think for all of those Black and brown and trans and other marginalized folks who have come before us, this really speaks to them. I hope that, we see you, we hear you, and it's important. I think that in terms of the pending cases, I wanted to mention go back to sort of where Kai started, and that's in the federal sector. And that's where the action sort of started with the EEOC at the beginning of the so-called revolution. And in the agency where I work now at the Office of Special Counsel, we, as I mentioned, interpret civil service laws. And there have been long-held protections in the civil service laws for individuals based on sexual orientation and gender identity. And there are materials on OSC's website, as well as in other parts, that talk about how federal workers can make informed choices about the various different routes that are available to them in order to vindicate their rights, including information about the remedial schemes that are available. And so I think this decision will further strengthen those protections and help us counter any lingering doubts about what sex discrimination means in the federal sector. And there are many pending cases that will be impacted by this decision.
Thanks, Louis. Does anybody else have anything to add?
Yeah, so I would just say I am not the constitutional scholar here, but I would say Black and brown trans women also have disproportionate engagement with law enforcement, police, confinement issues. And so I would hope that this also gives a boost to some constitutional claims that that LGBTQ people would have generally in those situations.
Yeah, actually, let me jump in on that because, again, the fact that this was the definition of sex discrimination, well, then obviously sex discrimination gets heightened scrutiny, right? So sexual orientation, gender identity discrimination gets heightened scrutiny. I mean, I don't know how you would parse it out any differently. And I think particularly in this moment in time, yes, I mean, Louis, you said sort of dark moments and challenge. That's right. But you know what, really in the last few weeks, I think we've also seen the power of people, right? And the fact that, Black Lives Matter, and what does it mean to be Black in America today? And then what does it mean to be LGBTQ Black person, a brown person? I totally believe that this moment now, I think, is like the Me Too moment, the Me Too movement, which talking to employers, that has made a difference and it continues to make a difference. Talking to employers now, I see this movement now in terms of Black Lives Matters and stuff, that's having an impact. We have to make sure that we're part of that coalition, keeping it going. Not only, of course, because we in our own community, crossover, but just as a form of coalition. And the constitutional piece will help, the heightened scrutiny.
Thank you, Kai. This is the big question lingering in the room. And I know that I and many of our attendees are very concerned about how soon and how broadly employers with religious or moral objections will seek to gut these hard-won protections under Title VII. So I'd like to ask the panelists to please speculate on settings and/or circumstances where they could foresee the new protections would be able to withstand challenges where RFRA is used as a defense, and what some examples might be. Kai, would you like to start?
Sure. I also want to say, because I've been going through the questions and they're just such good questions, obviously stuff about religion here, and I love seeing people that I know, Pat Kane, who has worked so much on this, various issues, Richard Fulton. So about and even the way those questions are said, so Pat Kane saying predictions about the possible success of religious liberty to these claims. And Richard Fulton, who's been a huge, fantastic worker on religious liberty, saying, okay, well, what will this mean for Orthodox Jewish or Catholic schools or worship or etc.? Here's the plus about this. This isn't like a new law that Congress had to pass and we had to argue about religious exemptions, right? This is Title VII. So Title VII has exemptions already for religious organizations, schools, houses of worship, etc. They already have a religious exemption. You know, to prefer people of their own religion, that'll have to be litigated, how that's going to apply, but that protection is there, right? So for the people who are saying, oh my God, what does this mean now for religion? No, they're protected already under Title VII. There's a ministerial exception, rabbis, priests, imams. We'll have to see what the court does with that. And then finally, without a doubt, we have a Religious Freedom Restoration Act that says if you burden someone's religious belief, the government has to have a compelling interest, and the burden has to be narrowly tailored to that compelling interest. And certainly people will argue, I think correctly, it's a compelling interest not to have discrimination against LGBT people. And the only narrowly tailored way to get there is by having this type of law. But, you know, those cases will come. Handing over to anyone else.
Shannon, do you have anything you'd like to add?
Not particularly. I think I covered it. I mean, of course, there's a lot of concern that the court may create some significant new religious exemptions. But I think we just have to be vigilant and make sure that we are doing our job, presenting them with the strongest arguments about why doing that to any significant degree could really be dangerous and could have a lot of unintended consequences. And I'm encouraged so far. I think, for example, the briefing in the Fulton case that's in front of the court right now, some of the briefs urging the court to be cautious, even from some of actually pretty conservative or moderate to conservative scholars, I think have been very impressive. And I think that those concerns will be given serious consideration by the court.
Right, and I think the only thing I would add to what Hai and Shannon has said is that, you know, also you look to states and localities that have already for years had anti-discrimination protections in this area that also have very strong protections against religious discrimination. So these are not mutually exclusive. They can coexist. They've coexisted in many areas of the country for very long. And so again, just to use these spaces as an example, but you know, as Hai said, people will litigate. These are the things that will be brought, and we will see the litigation. So,
thanks, Carmelyn. We have had a couple of people ask, and I just see it's been typed about anybody's thoughts about the but-for causality standard that was in the opinion, and I was wondering if anybody might be able to comment on that.
Well, the but-for is what gets us to the result. I mean, the but-for is fine here. It's saying, right back to the same example, Martin and me with the pictures of our wives, you know, but for the fact that I'm not a man, I wouldn't have been fired for doing that. But for is the strongest thing we can get. And the main thing that the court did is, oh yeah, you have to show intentional discrimination, and then said, if you're discriminating against a gay or transgender person, but for that their sex, they wouldn't have been discriminated against. That counts as intentional discrimination. You don't need animus. You don't need malice. You can say, I love LGBT people. But if you've discriminated against them because they're gay, lesbian, bisexual, transgender, that's but for, that's because of.
Can I just add to that, that the same way it was so wonderful that the court fully embraced the per se or textualist argument, which is our strongest argument, it was also wonderful that they went ahead and walked through the but-for causation analysis, because that's the most demanding test that one could possibly require under Title VII. And they could have kind of ducked that and said, well, we're just going to examine whether it's in any way motivated by, they could have just relied on a lesser standard that arguably would pass muster under the statute, but they helped us out a lot by going right through the but-for test and examining but-for causation, because that's going to apply across the board to so many other statutes. So that was really helpful. It's honestly kind of hard to imagine how this decision could be any more helpful to us in litigating claims on behalf of our community under all of the other federal sex discrimination statutes that Alito lists in his dissent, 100 plus.
And I think any concerns that, and I've heard about them as well, that, that the standard in Title VII for this is motivating factor. So why is there all this language about but for? It's as Kai and Shannon said, and the majority decision says, while we understand motivating factors in the statute, it meets this higher threshold of but for causation. And so that is, for all the reasons that have been articulated, a stronger position for us to be in. And I don't think it detracts from the way some might, that, that's now going to be the standard that's being used in Title VII for other things. I don't think we have to be concerned about that. I think it just helps us in that if we can meet this standard, we can certainly meet any other lower standard that's in the statute.
Thank you. I wasn't quite understanding why people were so concerned about it. Listen, but for does not take away the fact of motivating factor. I mean, that's Price Waterhouse. They did not overrule Price Waterhouse. Let me tell you, certainly this is, all my clients know it, right? If race is a motivating factor, it doesn't matter if there was also some other factor, right? And they know that, and that's really clear that it's not changed that one iota. What is sort of what I thought was so important about this is the hardest thing, and Shannon knows this, and the hardest thing about that straight per se argument was the causality, because they kept saying, well, no, it wasn't because you're not a man or woman. It's because you were gay. Like that was that other thing. And that's what was really going on. And then in the dissent in the Seventh Circuit, I mean, that was a really strong argument. And here, Gorsuch used exactly the cases he needed to use. The one, Martin Marietta, where they just discriminated against women who were mothers of small kids. So they were discriminating against mothers, not around women, because they had lots of women, and the court's like, that doesn't matter, because but for the fact that she was a woman, a mother, because you weren't discriminating against fathers, she would have been able to get into your workplace. So this did not overrule Price Waterhouse motivating factor one bit. I know where we are. I want to make sure, I don't know where Nancy Polikoff's question went, but it was a great question, and I'd love to hear what other people think. She says, how is this going to affect someone who uses the pronoun they when they apply? Okay. And I think that's a great question. I actually would hope that, and I've been saying this actually with companies, a lot of them wanting to change, male, female, non-binary, other, very much like wanting to say, what do you want in terms of your pronouns? But I think, I feel like I could easily see a way to argue it, but I just think that's a good point, because we needed to do this male-female argument for this case. But I think we want to make sure that the focus on that binary doesn't end up then being hurtful for folks who are non-binary. So Shannon and Carmelyn, I would love to hear what you think.
I was just going to add that I remember I was sitting at the argument listening, and I kept cringing because I kept thinking to myself, wow, Non-binary people are completely non-existent in this. And it's, you know, and fearing that. So I think it is a great question. I can imagine ways of arguing it, but I feel like even at the argument, we were anticipating that would be a lingering question.
Yeah, I'm a lot more optimistic than y'all are about that, because I think if you, I don't see how there's any way that the actual analysis the court applied would not fully and completely and plainly and directly apply to someone who says, I don't identify as either male or female, and therefore I want to use a gender neutral or non-binary pronoun. That is sex-based. That is just as much an inherently sex-based identity and characteristic as a transgender person. You can't even conceptualize that identity without taking sex into account. So I think it'd be really hard for them to wiggle out from under that.
Yeah, I actually want to second that, because that's why, you know, Gorsuch saying, how could you even think about this, that was gay, transgender, without thinking about sex? How can you possibly think about someone saying I'm non-binary, and then you say, oh, well, I'm going to discriminate against you because of that? Well, clearly you're taking sex into account. You're taking the fact the person isn't identifying as having one of those, having male-female sex. However, Shannon, we all know that we have to stay on top of this, because there'll be judges out there who may not think that. So that's why I thought it was a good question.
But I also, go ahead, Shannon.
No, you go, Carmelyn.
Just going to say, but I also think this is where the education piece of this is going to be so key. I mean, I also think one of the reasons we are here is because, you know, the law was behind. The law here caught up with what, you know, the public is living and experiencing. And I think I think it is true that even within our own LGBTQ communities, people don't have a great understanding of like gender fluidity and what it means to be non-binary. So I think that the education piece, if going into the type of arguments, Shannon, that you're talking about, I think is going to require that there's more education on that, more understanding, so that we can normalize what those lived experiences are.
I was just going to say the same thing. We were trying to say the same thing, because I don't think there's anything at all problematic. To the contrary, in the actual legal analysis in that decision, it's like right on square, you know, it's exactly what we need. No, the only possible problem would be the lack of familiarity of the courts with non-binary people, which, by the way, was our same problem that we had for decades with transgender people. It's not like our arguments suddenly got more logical or compelling. It's just the courts became more used to seeing transgender people, and we did a good job of educating and humanizing, and that's exactly what we have to do. And that just reminds me of one other little thing I want to say about that decision, because it's so dry and, you know, it's so logic choppy, and that's fine because that's how they did the textualist and per se argument. So I am not complaining about that. But I did note that the one place in that decision where there was a little bit of emotion and human empathy and warmth was the paragraph describing Amy Stevens. I just love that. It's very understated, it's low key, but, you know, they described in, I thought, very moving, clearly empathetic way, like her struggle to come out and come to terms with being transgender and to transition. And it was just really, and talked about her loneliness and despair. I mean, that it was really the only show of emotion in the whole decision. And it was just really beautiful. And the fact that the court didn't falter one time, didn't put one little tiny foot wrong ever in referring to her wholeheartedly as a woman and female. And even the dissents did that. So I just think that was so important. And that human, Carmelyn, like you're saying, the human side of this is just every bit as important as the law, if not more.
We are at the top of the hour, and I know all of you are extremely busy. I know that we have a lot of questions that probably went unanswered, and we could talk for another, 2 hours, but we just don't have the time. I want to thank everyone for joining us on this free webinar, and I want to express my gratitude, the gratitude of the Commission on Sexual Orientation and Gender Identity, and the Commission, or Section of Civil Rights and Social Justice, for having all of you, this esteemed group of panelists, join us today. You are doing and you have done such critical work, and I thank you and we thank you for taking the time out of your schedule to share the experiences. I know that this was put together very quickly, and I appreciate all of your commitment and willingness to just jump on this panel as quickly as we could possibly get it scheduled to work with all of you. I want everybody on the program to know that the section of Civil Rights and Social Justice continues to provide free webinars and resources for legal professionals and advocates nationwide, and we hope this helps you in your work. And again, if you can, please consider joining and becoming an active member of the ABA. You can do so on our website at ambar.org/CRSJ. Please visit the SOGI Commission's website. We have free resources and free webinars. You can learn about our awards along with CRSJ's awards, nominate the amazing people that are doing the amazing work for the for the Thurgood Marshall Award, for the Stonewall Award, and everything else that the ABA offers in the realm of diversity and inclusion. We are one family, we work together, and I'm so proud and honored to have been here today. You'll be able to find more information about the free programs that CRSJ offers on its website, and you'll all be receiving information about the recorded program and some of the additional materials that our panelists mentioned today. So best of luck in your work, and stay safe, everyone. And again, thank you. It was great to see your faces.